Hello. For some reason, I can't join it from my computer.
We can hear you and see you.
Okay, well.
Okay, well, let's get started. Thank you all for joining. My name is Megan O'Neill, and I'm faculty curator for the Art of the Americas at the Carlos Museum. I am honored to introduce Dr. Craig Womack, Associate Professor of Native American Literature in the Emory English Department. Of Creek and Cherokee ancestry, Craig wrote the book Red on Red, Native American Literary Separatism, and the novel Drowning in Fire. The Carlos Museum is so honored to co-sponsor today's panel on Friedman claims, and it's a follow-up to the first McGirt panel that Craig chaired in October 2020. Our co-sponsors are the Hightower Fund and the Native American and Indigenous Studies Initiative at Emory. And I hope you will check out the Native American and Indigenous Engagement website at Emory to learn about upcoming programs. We've just put that in the chat. There's a program tomorrow and then another next week for National Public Health Week. And I just want to thank Craig for all you do for the Carlos Museum and for Emory. We will miss you so much when you retire, but can't wait to hear all the music you make in your spare time. And now I'll turn it over to Craig and to our wonderful panelists. Thank you all so much for joining us today.
Thanks a lot, Megan. Megan is an art historian, and her specialty is Mesoamerican cultures, and she also works with the Carlos on exhibits that have to do with Native peoples of the Americas. I want to welcome everybody to Emory University, where this program is originating from, and welcome you all to Atlanta, and just say that Emory University is located both in terms of its current location and its original location on Creek Treaty lands. This part of Georgia was opened up when the Creek Nation signed a treaty that some people refer to as the first Treaty of Indian Springs in 1821. And it opened up both the original site of Emory near Covington, Georgia, which in the subsequent decade in the 1830s became known as Oxford campus. And it also opened up the part of Atlanta where the Emory University sits today. In the following decade, in the 1830s, Emory was founded in 1836, which of course is exactly the same year as Creek people were forcibly removed from their remaining lands in Alabama. So that just gives you a little bit of idea very briefly about our location on Creek lands. Today we have three distinguished panelists with us. One is Marilyn Vann, and she is president of the Freedmen of the 5 Civilized Tribes. In 2018, she won a Human Rights Award from the Oklahoma Universal Human Rights Alliance. And that same year, she won a Statesman Award from the Cherokee Nation. And I have to say that this particular award restored my faith in humanity because I did not think that I would live long enough to see Marilyn Vann win an award from the Cherokee Nation, not because she doesn't richly deserve it, but because she had faced an uphill battle for so long working on these issues. So when she won this award, I thought, well, maybe our species is in fact worth saving. It was a good day for me. And Eli Grayson is a Creek activist who was inducted into the Creek Nation Hall of Fame in 2014. He has lived out in California for a number of years and is currently living kind of both in California and Oklahoma. And he served as the former president of the California Creek Association. Muscogee Creek people have a lot of citizens in Southern California and the Bay Area as well, including some of my own relatives. And then John Paris, who we don't see on our screens yet, but we certainly hope to soon, is an Oklahoma attorney, and he's been an advocate and advisor to the Freedmen on various claims and legal issues. And his current area of interest is how this Major Crimes Act, and thus the McGirt decision, the recent Supreme Court decision, potentially applies to Friedman as well. One of the things I want to say about this issue is that all too often it gets depicted as this sort of side issue or tangential issue or something not quite as important as other things we should be talking about. And we had a big symposium on McGirt in the fall, and I feel guilty, to be completely honest, that we may have contributed somewhat to that failure to talk about this enough, because we did not get to talk about Friedman issues during the symposium. So we wanted to do this today and spend the afternoon really delving into this. And I just want to say this: if these particular issues are not about sovereignty and citizenship and what it means to be a tribal person, then I do not know what is. This is at the heart and soul of the kinds of things I think that we should be talking about. So I'm going to spend just 10 minutes of your time talking about a short story. I'm a literary specialist, and I want to tell you a tiny bit about something that Alexander Posey wrote. And if you talk to people within the tribe, they usually associate with him being a poet, and that's how they know him. But he also wrote some short fiction, and one of his most interesting bodies of work have become known as the Fuss Fixico letters. And he wrote these comic letters to the editor of the Eufaula Indian Journal, which was published in the territory at the time and still is published today. And he took on this fictional persona of a Creek full-blood who doesn't speak English very well. And then he uses this as a kind of comedy forum to talk about the political issues of his day, especially leading up to Oklahoma statehood. Today, I'm concentrating on a short story, and I'm just going to give you a little bit of historical background, because the panel is going to touch on this much more deeply than I am. And so I want to leave that for them. But just in terms to say enough to talk about this story in regards to who the Freedmen are, I want to start with the fact that Creek people's contact with African peoples stretches back in time really far. And in fact, some folks speculate that even before European contact, that it's possible that African peoples may have been in the Americas. And along this line of thinking, there were seafaring people in Africa, and the reasoning is that if you fell into certain currents, your boat fell into certain currents in the Atlantic Ocean, you might end up in the Americas, whether you wanted to or not. So there's that as a possibility. But in terms of the written historical record, when contact first occurred in the Southeast with these Spanish explorers, those expeditions were well chronicled. And one of the most famous of them, of course, is Hernando de Soto's expedition, which had official writers on board to tell about what happened every day. And so one of the things these writers tell us is that slaves were with them, slaves escaped from the expeditionary forces, they made their way into southeastern tribes. So that's the early 1500s there. And then, of course, given the fact that Creek people's homelands are in Alabama, Georgia, the heart of the American slave empire, especially after the invention of the cotton gin, when this thing really starts to ramp up, Creek people, well, escaped slaves, made their way into Creek villages, and also Creek people practiced slavery to varying degrees. And in terms of slaves ending up in Creek villages, if you think about this, if you had to escape slavery and your choices were making it to a free northern state like Ohio or all the way up to Canada or something, would it not be easier, if possible, to escape maybe 20 miles to some Creek village where you already had kinfolk? So Creek people had this extended kinship system that allowed for taking in these other tribal people and adapting them, and for them becoming culturally Creek. And tons could be said about that, but we'll leave it at that for now. And then Creek people also practiced slavery. In some cases, this was not a huge proportion of the tribe, but there were rich are wealthy mixed blood Creeks influenced by Southern agricultural plantation farming systems, who had slave operations that were fairly large size, where you would have the worst forms of chattel slavery. There are other kinds of slave practices in Creek country, including ones that are hard to understand from a contemporary perspective, where maybe slaves would also be family members, husbands or wives. And I'm not trying to create some sort of hierarchy where there's one kind of slavery that's okay and another that's not quite as bad, but I'm saying there was some varied practice of keeping slaves in Creek country. When the Civil War came about in the 1860s, Creek people, of course, had been removed to Oklahoma. They had been there for 2 decades by then. And the Creek government officially sided with the Confederacy. Now, this was much more complicated on the ground. The nation was pretty equally divided. Very large numbers of people sided with the Union, fought on behalf of the Union. But in Creek government, there were a substantial number of Creek politicians who had blood ties with the American South, economic ties, deep relationships with Southern people. So they sided with the Confederacy. And of course, thankfully, the Confederacy lost the Civil War, and Creeks then had to renegotiate one of their treaties. And this was the Treaty of 1866. And like most treaties, they had to make a land cession, but also in that treaty, freedmen and their descendants were made full members of the Creek Nation. Now, there's a couple different ways of looking at this. And one of the things you hear people saying is that this was the sort of foreign imposition on the Creek Nation, and they were forced to accept freedmen as tribal citizens. But other people have argued compellingly, in my view, and one example is Gary Zeller in his book African Creeks, that there was a group of people, a faction of Creek people that lobbied hard, that worked hard to get freedmen accepted as citizens in that treaty. And the reason for this is because some of these Creek politicians, particularly Creek politicians that were allied with the ceremonialist or traditionalist faction of the tribe, politicians like Isparheche, they depended on freedmen votes to get elected. That was part of their alliances and how they stayed in office. So turning to this story, this Alexander Posey story takes place just before statehood. It takes place at a time period where the freedmen have not been disenfranchised yet. They're still full members of the tribe. It takes place at Bald Hill, which is where the Posey family ranch was located, just 10 miles west of Eufaula. The title of the story is Just About a Midland, Sir, and it's about bacon, not bacon, bacon, the kind you eat. And in this story, the narrator's father gets a visit from one of their neighbors. This Afro Creek guy, a freedman neighbor by the name of Jim Quebner, comes over to visit, strikes up a conversation with the narrator's father. And as the story unfolds, it's obvious that the narrator's father also has common relatives with Jim in the Afro Creek community and the freedman community. And they talk about one of their relatives, cousin Sharper. And Jim reminds the narrator's father that one time he bought a cow from cousin Sharper, and Jim helped him transport the cow. And then Jim tells this comic anecdote. I guess this is only funny if you're Creek, maybe, but he recalls being out at the stomp grounds watching a stickball game, and somebody gets walloped upside the head with a hickory stick, and the ball game has to be stopped, and the medicine person has to treat this injured ball player before they can go on. And Jim is really just working his way up to what he really wants. He wants to borrow some bacon. That's the title of the story, and he just wants a Midland. That's the portion that he wants. And the narrator's father says, well, I'll tell you what, he says, you can have that bacon, but here's the deal. John Moore's running for principal chief. I'm stumping for John Moore. I'm trying to work up all the votes I can for John Moore. If you go into your community, in the Friedman community, and convince as many people to vote for John Moore as you can have that bacon. And Jim says, well, as it turns out, John Moore is my candidate too, so I'm more than happy to do that. He goes back to the community and tries to drum up as many votes for Moore's candidacy as he can. Unfortunately, this does not work out the way the two men had hoped, and John Moore does not prevail. He loses the election. But where the story ends is really interesting because it emphasizes the way in which, in spite of the fact that these two guys don't see their favored candidate elected, they continue to work together as neighbors and political allies. And the reason why I wanted to start this way is because it seems to confirm in a fictional format, albeit a highly autobiographical one in terms of Posey's family, but it confirms exactly this argument that Zeller's making, that there have always been a faction of the tribe allied with the Freedmen and working out a reciprocal relationship as political allies and neighbors and so on. So I just wanted to start out, and I will begin by asking any panelist who wants to answer this question to kind of fill in these gaps that I've barely touched upon. But who are the Freedmen of Indian Territory and why are they called Freedmen? So that's where we're starting.
You want me to start?
Sure.
Well, in the treaty, in Article 2 of the 1866 treaty, the people of African descent who was held as slaves of the Creek Nation and free blacks are not referred to as freedmen in the treaty. So it wasn't the freedmen got rights, it was their enslaved Africans. You know, the Article 2 of the 1866 treaty basically states things. One, the Creek Nation could no longer enslave people unless it's a form of punishment from somebody breaking the law and they're in prison. And then two, they're enslaved Africans, and also the free blacks who lived among them were now their tribal members. They're citizens of the tribe. And three, they had an equal interest in the funds of the tribe, and four, equal interest in the soil. And the fifth thing it declared was that the freed Africans, who are now tribal members, are to be treated the same as the native citizens. So it never says the word freedmen, the freedmen got citizenship. It doesn't state that. It states people of African descent who are among the Creek Nation. So, you know, so that needed to be said because people think, oh, the freedmen got citizenship as if they were free and when they got the citizenship. They were actually enslaved. So it's important to kind of distinguish that we're talking about several classes of people. We're talking about free blacks who were among the Creeks, who were usually, the free blacks in the Creek Nation were people who had one Indian parent or grandparent. They were part Indian. Yet their mother usually was the African person who was enslaved, and they received their freedom probably from their father, who was their slave owner. A good case would be like that would be a woman named Lucy Crosley, whose mother was a slave and father was actually Mose Perryman, a slaver. And everyone in the Creek Nation knows the history of Mose Perryman. The beginning of Tulsa starts with the Perryman family. So then you have people who were actually enslaved by the tribe, who were freed on June 14, 1866 by the treaty. And then they were made citizens, given the rights of Indians with an equal interest in the soil and in the national funds. So, you know, that needed to be said. Also, politically, in 1867, just before the 1868 Constitution, the Creek Nation established 3 freedmen tribal towns. They were called Arkansas Colored, Norfolk colored and Canadian colored. And they were on the same level as the other tribal towns that made up the Confederacy of the Creek Nation. And so politically, they had a person in the House of Kings and they had representations in the House of Warriors. So they were electing their own people as well. And also, the first person of African descent in the US that we know of that served on a Supreme Court was a man named Jesse Franklin, who was a enslaved person of the Creek Nation prior to being freed in 1866. And he was appointed to the Creek Nation Supreme Court in 1878. He died in 1883, sitting on the court. And we have interviews that he made to the US Senate on the hearings of conditions of Indian Territory. And they actually interviewed him. And it's fascinating what he actually talked about. So politically, the freedmen since 1866 were politically active. And of course, they picked and chose, depending on their tribal town, who they act. And oftentimes their tribal towns didn't even agree to what principal chief or the candidates running for principal chief in the same manner. Sometimes the freedmen tribal towns has split themselves. So, but that needed to be said to clarify that, oftentimes we think the freedmen got citizenship in 1866. People of African descent who was held by the Creeks became free in 1866. And then they were started to be classified as the freedmen descendants of the Creek Nation. And by the time of the Dawes Rolls, when the rolls were started to be written, it went from being a tribal town roll system to the by-blood roll and the freedmen roll, due to an act of Congress that basically created the two classifications in that roll.
Okay, thank you, Eli, for expanding on those details about Article 2 of the treaty and the history of these freedmen tribal towns and the two roles that were established. What some people might argue is kind of how we got into all this trouble in the first place.
It's really one role. It just has two classifications. And people just kind of try to define it as being two roles. It's the Dawes roll. It just has two classifications of citizens. And even among the freedmen, the freedmen roll, they're on the Creek Freedmen roll of the Dawes roll. There are 5 distinct classes in that particular role itself. So it's like in the by-blood classification, you have the by-blood members who are minors, who are newborns. You have the same thing in the freedmen classifications. So, and then in the freedmen classification, you have members of various tribal towns, so it's more complicated than just 2 separate roles. It was one role with many classifications, or basically I say chapters to that particular role. And when we start seeing it that way, then we can kind of end this argument that the freedmen were put on the separate roles to basically put them out. It had nothing to do with that. They were put on a separate roles. In the Creek Nation case, if you read the Burke Act of April 26, 1906, it says anyone found on the J.W. Dunn roll of 1867, they were to be placed on the freedmen roll, a roll to be made of freedmen people from that roll. And so, and that was mainly due to, you had a lot of what I call relics of the Civil War, Confederate Creeks, who were accusing Black people that were coming from Arkansas and places like that, claiming to be Creek Freedmen, others. And it was getting to be confusing. So there was a complaint to the Dawes Commission that we can't tell what Negro we're talking to, which was basically a lie, because we knew the Black people on the Canadian colored rolls, we knew the Black people on the Arkansas colored rolls and the Norfolk color rolls. So Congress said, okay, we have a role that Congress actually created with an Indian agent in 1867 named J.W. Dunn, who was to enumerate all of the enslaved Black people who were formerly enslaved by the Creeks, who had returned within 1 year of the ratification of the treaty, which is the language of the treaty. And he actually was supposed to enumerate people for 1 year in 1867. He actually only did it for 5 months. He got sick and he went back to Massachusetts. But Congress based the Freedmen rolls based on that. And what is very ironic, you have Black people on the by blood rolls who are not on the J.W. Dunn roll, but they are Black people. And a lot of people don't realize that the by blood rolls of the Creek rolls, Dawes rolls, a third of those people are of African descent. A third of them are people of African descent. So did we lose? Hello? Are we?
I don't think we lost anybody.
Okay. So a third of the people on the by blood rolls, the Dawes rolls, are Black people, are Indians with some African ancestry. But none of them are found on the J.W. Dunn roll. None of them. The Negro family, others on and on. Then you have the Freedman rolls, the Creek Freedman, the Dawes rolls that's under the classification of Freedmen. If you notice when you read those census cards, it always references the J.W. Dunn roll. Mother is found on J.W. Dunn roll. Father is found on J.W. Dunn roll. And thereby they were placed on that roll. Now, it wasn't a punishment. It wasn't anything whatsoever. We forget that this was supposed to be the end of the Creek Nation government. And the federal government had demanded that the Creeks divide up all of its lands. 160 acres apiece would be given to each tribal member, whether they were Freedman class or by blood class or Indian class. Everybody was going to get 160 acres, and everybody became a citizen of the United States under the 5 Civilized Tribes Citizenship Act of 1901. And so the Freedmen, if you were living between January 1st of 1898 and April 26th of 1906, living any point in that time period, you got 160 acres, whether you were 3 months old or 100 years old. If you were Indian and living between January 1st and of 1898 and April 26, 1906, you got the same 160 acres. There was nothing special about your citizenship as a Indian, because this was the end of the tribe. And unlike the Choctaw and Chickasaws, which only gave their Black people 40 acres and gave their Indians and intermarried whites 320, a lot of racism there. But in the Creek Nation, Cherokee Nation, Seminole Nation, there was equality there as far as the division of land within the tribe. And so people need to understand, even up to that point, the freedmen were treated with an equal share of the funds and an equal interest in the soil in the Creek Nation. And they were not put out until 1979, not 1906, 1979 is when the discrimination of the freedmen started. So anyway, I've talked enough. Marilyn might want to say something, John, too.
Yeah, let me jump in here for just to make a very few points. First of all, I've heard a lot of people, including attorneys, talk about the freedmen being African Americans, the freedmen of the tribes. Now, the freedmen of the Creek Nation, of the Cherokee Nation, and their descendants were not African Americans. They had no right to U.S. citizenship until the 5 Tribes Citizenship Act was passed in 1901. And again, this was just before Oklahoma statehood. So no one had dual citizenship that was a freedman or by blood member of the tribes. That was, it was just unheard of. Who either had U.S. citizenship, citizenship in a tribe, citizenship in Mexico, Canada, wherever. And And I think that's important to point out. Now, also, it was the federal government, and Eli, of course, has brought this up, which actually began using this term freedman. People in the tribes, your tribal documents did not call people freedmen. For instance, I'm pretty familiar with the Creek Nation, but more in the Cherokee Nation. If you look at the rolls that the tribe made, such as the 1880 census, which was created and approved by the National Council, people are listed in districts with their families. Now, you may have someone listed as a native Cherokee. Someone may be listed as an adopted colored or an adopted Delaware or the like, but there's no blood degrees. The blood degrees only came into place for allotment purposes. And if there had never been allotments until 1960, 1970, whatever, then this business here of the degrees of blood never would have existed in the Creek Nation, in the Cherokee Nation. And even so, when the Dawes rolls were made, the purposes of as I mentioned, the purposes of the blood degrees dealt with when your land was sellable. They put you down as a freedman. Your restrictions to selling your allotment began. Your land became unrestricted in 1904. If you were a member by blood, even with a small degree, your restrictions would not be lifted before 1908. A person with a high degree of blood, such as a full blood, your restrictions would continue. So this was the reason. This was the reason for these blood degrees, and and what happened in the different tribes wasn't even consistent. For instance, in the Seminole Nation, there were some people who were adopted citizens. There was a Oklahoma State case called let's see here, Lula versus Powell, where there was an adopted. I think it was a Comanche Indian. This person was, and who died in 1905, and the allotment was divided among this woman's children. Well, this woman it was just listed as adopted. There was no blood degree listed. But so then the question came, well, when would restrictions be lifted? So they said, even though a determination was made that even though there was no blood quantum listed by this person's Dawes roll number, they were still an Indian for purposes of when the land would be unrestricted. So it would not be in 1904. And in the Chickasaw Nation, there were also some adopted citizens that were not given any blood degree. There was a man named Kilo Brown. And I've never met this man's, any of this man's descendants, but he was supposedly a person who had been a Creek child who was adopted by some Chickasaws. And the Dawes Commission wanted to put him and his siblings down as freedmen. By this time, they were elderly people, but they kept fighting it. And so finally, they put them on the by blood roll. So now this was different, for instance, in the Cherokee Nation. Anyone who was deemed to be, quote, an Indian by the Dawes Commission, they weren't listed as adopted. Now, that's not to say that there was not a lot of several people that were down as native Cherokees on the 1880 roll that all of a sudden they're freedmen when the Dawes rolls were made 20 years later. This is just a little more background about the blood quantum, the Dawes Commission, and what was going on. And of course, later on, the U.S. government, they found a way to save money. If they began to say that only people who were quarter blood or higher were entitled to go to have Indian health care or qualify for certain services. So then, it became important to have a quote unquote degree of blood or a high degree of blood. Whereas at the time of the Dawes Commission was making the rolls, this concept was unheard of, that someone would be denied something as a member of the tribe. So no, as Eli said, no one was put down as a freedman. Is an idea that they were going to be tossed away from the tribe, because the idea of the United States was the tribes will not exist anymore. The reservation is going to be disbanded. But of course, McGirt has come, and we do have a Creek reservation. We have a Cherokee reservation. But I thought it was important to, now also, of course, with this, with the blood quantum and the like, you could have a parent that was put down with a degree of blood, and their child might be put down as a freedman. So what did the Oklahoma court say? In one of the cases, and again, something came up with whether or not this was a legal conveyance of land by the daughter who was put down as a freedman, because later on she said, well, I'm an Indian. This conveyance is not legal. But they said, well, for property rights purposes, you are not an Indian. That didn't, but she could be an Indian for other purposes. Now, this sort of thing has come into play. For instance, in the Cherokee Nation, there were persons listed as freedmen who were received the Guillen-Miller roll payment. They would not have received the payment if they were not deemed to be Indians. I know in the Creek Nation, there were some freedmen who received a payment, I believe it was in the 1970s, Eli, if their ancestor was put down on the old settler roll in the 1850s. So the U.S. government has, or from time to time, takes positions that you can be an Indian for other purposes, even if you or your ancestor was a freedman.
I want to see if I understand where you're going with this, because one of the critiques of the Freedman roll is people will say, well, it doesn't have a blood quantum on it, so it's not as authentic as the by blood roll.
Yeah.
And I think if I'm hearing this right, what you're saying is that was a relatively later adaptation for allotment anyway, putting those blood quantums on. Is that kind of where?
Yeah, and when you read the treaty, when you read Article 2 of the treaty, nowhere in the treaty does it say that these people of African descent for citizenship need Indian blood. It doesn't say, Creek Nation, you could free your Negroes as long as they have Indian blood and make them citizens. You're in the state of Georgia. When Black people in Georgia were emancipated, Lincoln didn't say Black people with white blood are emancipated and they are now citizens of the state of Georgia. He didn't say that. Neither did they say that for Mississippi, nor do you find African Americans in Mississippi and Alabama and Georgia saying, I have rights in this state, in the state of Georgia, because my fourth great grandfather was a white man. Nobody says that. And so in the institution of slavery in Indian Territory, though many of the slaves were part Indian, nowhere in these treaties does it say you need Indian blood to be free, to be made a citizen, to have rights of the other Indians, to participate in the soil, to have an equal interest in the funds. It doesn't say you have to have Indian blood. We made that stuff up today. That's a modern day creation. But when you go look at the language of the treaty, it's not there. So when it came to the freedmen getting their allotments and the blood quantums being recorded or not on there, it was irrelevant because they got an allotment because they were a tribal member. Mm-hmm. And their tribal citizenship was not based on an Indian parent. It was based on the parent or people themselves, because there are many people on the Dawes Rolls that were enslaved, have been enslaved by the tribe, still living in 1898. You know, so You know, so I think it's important if you bear with me. Do you mind if I just read that little short paragraph?
Go ahead.
I don't know how much time we have, and I know John is sitting there. Okay, Article 2, the Creeks hereby covenant and agree that henceforth neither slavery nor involuntary servitude, otherwise than in the punishment of crimes whereof the parties shall have been duly convicted in accordance with the laws applicable to all members of said tribe shall ever exist in said nation. And as much as there are among the Creeks many persons of African descent who have no interest in the soil, it is stipulated that hereafter these persons lawfully residing in said Creek country under their laws and usages, or who have been thus residing in said country and may return within 1 year from the ratification of this treaty, and their descendants, and such others of the same race as may be permitted by the laws of the said nation to settle within the limits of the jurisdiction of the Creek Nation as citizens thereof, shall have and enjoy all the rights and privileges of native citizens, including an equal interest in the soil and the national funds. And the laws of said nation shall be equally binding upon and give equal protection to all such persons and all others of whatsoever race or color who may be adopted as citizens or members of said tribe. Now, it doesn't mention the word freedmen at all. It's talking about people of African descent who have been enslaved by the tribe. And so in there, it says a lot, even when we push up to this McGirt thing. It's clear in Article 2 that the freedmen or the former slaves who are made citizens are under the laws and protections of the Creek Nation. And we just overlook that. And I find it strange, even in a conversation this morning, someone was saying that the freedmen were not included in the McGirt decision, though nowhere in the McGirt decision does any of the justices say, oh, but this doesn't, we're not talking about the Negroes of Indian Territory. We're not talking about the Blacks. It doesn't say that. But if you're going to talk about McGirt and talk about Article 3, which is what McGirt is about, and you're going to skip over Article 2, which is talking about the people of Indian Territory, you know, you're missing it, you know. And quite frankly, the Creek Treaty, and this is very interesting, the only class of people in the Creek Nation that has any treaty protections are the freedmen, are the former slaves. They're the only people mentioned. If the tribe had a policy that you had to be a full blood or 3/4 and all that stuff, and that's what their constitution says, then everybody else don't have a leg to stand on, because there is no treaty that protects anybody else. But there is no legal right for them to kick the freedmen out. We forget about that. We ignore that, you know, and pretend that it's not there. But any you know, 7-year-old reading could read that and go, oh my goodness. You know, there's a particular class of people. And the treaty, let's be honest, the treaty was written for a purpose. It was written because of the Civil War. And the Civil War was about freeing Black people. And so when you talk about the 1866 treaty, this treaty just didn't pop up from nowhere. It popped up for a reason. And at the very beginning of it, it deals with the condition of those enslaved Africans in the Creek Nation.
I wanted to ask John if he wants to weigh in on any of this. He joined maybe a minute or two after we started, and the question was simply the beginning question: who are the freedmen of Indian Territory, and why are they called freedmen? So I want to. We haven't heard from you yet, and thought it'd be nice if we could hear your voice for a second.
Yeah, well, just multitasking a little bit, but it's yeah, been an interesting discussion, been following on, and I don't have too much to add. The history has been interesting. Just learned a few things too. What, from a legal standpoint, we're just, we've got a line of cases that say you have to have Indian blood, of course, and then the Cherokee Nash decision says you don't have to have Indian blood. So the history is enlightening. And I've got to get that out to the courts pretty soon.
Okay. The next question was alluded to briefly already a moment ago, but it has to do with jumping ahead to 1979. So we have this situation where from 1866 to 1979, descendants of African slaves, later known as the Freedmen, are full citizens of the Creek Nation. And then we have this turnabout in 1979. So I was hoping one of you all would explain a little bit about what went down in 1979. How did the Creek Nation reach this decision to disqualify the Freedmen from citizenship?
It was a hot mess what went down. That's the truth. There were a bunch of payments back in the 1970s. And one of them had to do with the Laurel Creek payment, which is actually an issue that's in the treaty. And it was to pay any of the Indians and freedmen who had allied with the with the Union and Confederates. And the treaty said that they were supposed to receive reimbursements for whatever their losses were. If they lost a chicken, their house, if their wagon got burned down, whatever, anything that they lost, they were able to make a claim against the United States, and the US said it would pay it. And upon the signing of the treaty, the tribe got 100,000 grand up front. It was roughly about 1.3 million in total claims. And it wasn't monies that were supposed to be paid to the Muscogee Creek Nation. It was supposed to be paid to individual who had allied with the Union, basically. So so the tribe got 100,000 bucks, cashed the money, paid it out to who it was supposed to go to, blah, blah, blah. This is way back in the day. And then when the Creek Nation wanted the rest of the money, they constantly would have to go to the Court of Claims to file lawsuits again and again. Judge Stidham, G.W. Stidham, who filed consistently while he was alive, even coming up with a Stidham roll that lists all the people in the amount of money that the federal government owed them. It's called the G.W. Stidham rolls. And so we would win in the Court of Claims, but then when the Congress comes in, they would have to approve it. They wouldn't approve it, and then it'll start all over again in a new Congress. Finally, in the 1950s, Congress said, we're going to pay these monies out. You remember during the termination period when they were paying off all the tribal debts that the federal government owed to Indian tribes. This one in particular was owed to not the Creek Nation, but to Creek citizens and their descendants, freedmen and Indians, who had allied with the Union. Well, what I've read about it, it was about the 1970s, it was up to $38 million with interest on top of it. And part of that money, a great percentage of it belonged to the freedmen in the 1970s. They never got it. And at the same time that this was going on, there was the leaders of the Creek Nation at that time that, started this thing. We need a new constitution. And that new constitution did many things. One, it took the power structure away from the tribal town Mikos. We ended our tribal town system under the new constitution in 1979. And mind you, the Creek Constitution in 1979 never mentions anything about the 1868 Constitution. It doesn't even say it doesn't exist. The laws are old and forgotten and we don't need them anymore. None of that. It's just written as if the 1868 Constitution never existed. So under the new tribe is what they say they established, a new tribe with a new constitution. They required that the roll would be the by blood roll basically, and thereby eliminating the freedman roll. So you can't help but to think when this went down, Also, the same time went down was a huge payment that belonged to Freedman descendants, and they never got their money, but the tribe got the money. So there's a lot of layers to what was being said. You know, we're putting these people out because we want a tribe that's Indian. We don't want Negroes in our tribe. You know, we want it to be a by blood tribe only. And though it was a violation of the 1866 treaty, that's number one. And then to tell the voters that these people don't have any rights because they don't have Indian blood, but never telling them that they never needed Indian blood to be a member of the tribe. That was the reason why they were members. They never needed it. And to say you're going to change that now, 100 years, 110 years plus years, 115 years after the Civil War, you decide you're going to change what our ancestors did in 1866 after they fought a war over this, you know. And so in my personal beliefs, I think not only was it about racism, which pure simple racism, we want the blacks out. It was also an economic element to that. They are to be paid a certain amount of money. And then you go back to the treaty, which says that they have an equal interest in the national funds. So you're taking their money away from them as well as their citizenship status. So it's complicated. It's layered with racism, but it's also layered with just straight out theft. You know, but can I go back and say something that's really important back in when the Dawes Rose happened? The Freedman allotments in the Creek Nation, just in the Creek Nation, totaled 1,092,240 acres. The Creek Freedmen, 1,092,240 acres. Now that was just the Freedmen. You have a third of the by blood roll are people of African descent too. They have some Negro blood, you know. So you're looking at in the Creek Nation, roughly about nearly 1.567 million acres of land within the Creek Nation that at statehood, because of Jim Crow laws with the one drop blood, you're a Negro, one drop of African blood, you're black. You had that much land that was collectively owned by black people in the Creek Nation, whether you were a black Indian or whether you were freedmen. Now, when you think about Georgia, the state you're in right now, in 1900, there was less than 1 million acres that all black people in the whole state of Georgia actually owned, and it was mainly in debt. In the allotments of the Indian Territory, there was no debt. The land was free and clear. There was no banknotes. It was free and clear. So when you think about, you know, communities like Greenwood that we call the Black Wall Street, and Bowley and Rentisville and all of these black towns that formed at statehood, they formed because of the land ownership collectively of the black people of Indian Territory, Freedmen and Black Indians. And I'm not talking about the Indians and the white Indians. I'm just talking about the Black Indians and the Freedmen. You know, so, and then you think that the state passing these Jim Crow laws, the grandfather clause, all the things that they tried to push through, where if you were a person of color, one drop blood, a person of color, and say, for example, you had a wife and you had 7 kids, and each one of your kids were living between 1888 and 1906, each one of them received 160 acres. And you and your wife, both Creek Freedmen, received 160 acres. You own several square miles of land. And yet, under the new state of Oklahoma, they immediately said, you have no voting rights. You own land, but you have no voting rights. And then when you think about, and that's just in the Creek Nation, you got the Chickasaw Nation, Choctaw Nation, Cherokee Nation, and Seminole Nation with the same numbers of acres that were being controlled by black people as statehood. And the new state then allowed black people to vote. Now, you can even step it beyond that. In the Indian Territory with the 5 tribes, half of the allotments went to females. who had no voting rights. And you could be a white man from Atlanta, Georgia, and bring your butt to Oklahoma 2 days after statehood, and you're given the right to vote. So you pass laws to dispossess the Indians and the freedmen of their lands. And the government actually stepped in to give some protections to the Indians, but none to the freedmen. And they washed their land decade after decade, these millions of acres, nearly 3 million acres in Indian territory went to Black people. And today, 2021, there's less than 1% or 1% of all that land that's still in Black land ownership. And we're not angry about that. We're too busy fighting over citizenship crap. And yet the real stuff that went down is we got the reservation back in McGirt, but we don't get the dirt back. Let's think about that. We don't get the dirt back. We could say, oh, this is our reservation. I live in my reservation. And if I commit a crime, I get arrested by the light horse police. But my neighbor across the street still owns Creek land. I don't know if y'all want to hear that, but hello.
I was wondering if Marilyn also wanted to add something to just a little bit of this history of what happened in 1979. And I was also thinking, I don't know if you want to ask this in relationship, especially since you've been so involved with Cherokee stuff, like what was happening alongside this 1979 decision in the other Southeastern tribes, many of which sort of followed suit, not all of them, but in the early 1980s. So did you want to say something, Marilyn?
Yeah, let me just, jump in here and just add a few things because Eli has really covered a lot. One of the things that some people don't realize is that when Oklahoma became a state, the very first law that was passed was Senate Bill number 1 that immediately classed everybody in the state of Oklahoma as legally being white, except for those persons of 1 drop of African blood who now became Negroes, were subject to all of these Jim Crow laws. So all of a sudden you have people who had been leaders in the Creek Nation and the Cherokee Nation and the Seminole Nation. And there were places where they couldn't eat. There were the universities. The blacks, the people of African blood in Oklahoma were limited to go to Langston University. But yet a full-blood Indian or a half-blood or whatever could go down here to University of Oklahoma, study law, study engineering, study whatever, or University of Oklahoma State University. I'm not saying that there was not prejudice. So part of this, when we get to 1979, is that you have all of this history here where it's the kiss of social death to be known as a person with African ancestry, to be a person who consorted with Negroes. Now people of Indian descent, and granted, most of these were people who did not appear to look like stereotypical Indians. 1907, 1908, Robert L. Owen, he was a U.S. Senator from the state of Oklahoma. Cherokee. We had a W.W. Hastings. He was a congressman, also another Cherokee, very small degree of blood. Also, we even had an Oklahoma governor, Johnston Murray, who in 1950, he was his father, Alfalfa Bill Murray, had been a governor of the state of Oklahoma. He was a lawyer. And as I said, in 1950, his son, Johnston Murray, he was actually the first Indian to be a governor of the state of Oklahoma. So then, as I said, 1964, we get the Civil Rights Act, we get the Voting Rights Act all across the United States. Again, this doesn't have anything to do with tribes. But when you get to 1971 and the Principal Chiefs Act is passed, and because I need to backtrack a little bit. After Oklahoma became a state, almost all the tribal government functions were ended. By act of Congress, the tribal courts went away. The president would appoint a chief. And so in 1971, this changed. The tribes began to exercise sovereignty based on new laws passed by Congress. But you still had a lot of people who looked down on Blacks as their social inferiors. So when you come to 1979, you still had a lot of those folks who were used to Blacks being segregated, remembered how for most of their lives, Blacks hadn't been able to vote, hold office in the state of Oklahoma, be the mayor, be the governor. So no, they did not want these people. They did not want to consort with these Blacks. So that is a whole lot of it, as well as what Eli was talking about, the theft of the money. Each Creek citizen who was never supposed to have gotten the loyal Creek payment, because a lot of the people in the Creek Nation were Confederate Creeks. There were more who served under the Confederacy and the 5 tribes than were with the Union. In the Union, there were 3 Indian home guards. You mostly had Confederate brigades. That's the honest truth. In your Seminole Nation, you asked me to just touch on the other tribes. In the Seminole Nation, the people were the free. They had their bands, and there were 2 Freedmen bands. And they continued, I believe, to have band meetings, select band chiefs. And from what I have read, the Seminoles, they would elect a chief and they would ask the United States government to approve him, which usually happened until the president got mad at the chief. But anyway, it wasn't until about 2000 that when it again came to money, that they tried to kick the Freedmen out because the Freedmen wanted to share in some funding. In the Cherokee Nation, the Freedmen were in 1971, the Cherokee Nation began to exercise more sovereignty. The people started electing chiefs, electing a council. The Cherokee Freedmen, they were voting and the like, but then you start to get into the 1980s. The Freedmen, they did support the chief. Actually, it was Ross Swimmer. The second time he ran, they wanted to support Perry Wheeler. Instead of going and sitting down with some of the Black ministers, deacons, community leaders, and saying, well, what do you people want? It was just easier to say, well, we're going to stop you people from voting. So that most of the Freedmen didn't even get to vote on the chief. So Freedmen began starting to have problems voting, getting services, holding jobs, until we jump up to 2007, when there's even a petition drive to just formally put the Freedmen completely out of the tribe. So the Freedmen have been having these difficulties either as second-class citizenships, such as in the Seminole Nation, where they allow the Freedmen to vote, they allow the Freedmen to have their representatives, which when the tribe had to back off of putting the Freedmen out because of the lawsuit, Seminole Nation versus Norton. But they went around it by reissuing a people's card, stamping Freedmen on it, putting 00 blood quantum, voting purposes only on the back, trying to limit other tribes from servicing the people. So right at this moment, it's only the Cherokee Nation that's actually trying to honor the treaty. And of course, this really came about because of the cases Vann et al. Versus Norton, when it was originally filed in 2003, myself being the Vann on the case. And then later on, the Cherokee Nation versus Nash and Vann case, which was decided by Judge Hogan in 2017. So, you know, all through history, there has been a fight by the freedmen to enforce the treaty, to have our rights. And there have been forces within the tribes who feel their best way to exercise sovereignty is to, or racism, or control money, or control people, is to kick the freedmen out or marginalize the freedmen.
I wanted to ask the next question, starting with John, because I think this is one that's kind of in his realm. And it's since this 1979 disenfranchisement, what cases have the freedmen been bringing forward? And I know Eli and Marilyn have a lot to say about this as well, but I just thought I would ask John first. Are you with us, John?
I stepped away.
What'd you say? All right, I'm not sure where John is. His picture's there though. Anyway, we'll just open it up to everybody. So, well, you just started touching a little bit on this, Marilyn, in relationship to Cherokees, but also in relationship to Creek people since this 1979 disenfranchisement. What are some of the cases that have
Well,
been brought forward?
The first one was filed back in 1979, 1980 from a old Creek Latte named John Mcintosh. He was a Creek Freedman. Unfortunately, I believe when he filed that case, he was like 95 years old. So he actually passed away within, what I understand, a year of the filing, and no one ever picked it up and challenged it, as was the issue, you know. And so it went through a decade of Creek Freedmen applying for tribal membership. And let's go back to what happened in 1979 when the Freedmen showed up to vote, and they did show up to vote. It was strange. Their cars, they had voting cards. I have a copy of a number of them. They were, you know, taken at the table, and then their cars were taken in the back, and some of them were returned and some of them were not. And then it got word that the tribe wasn't letting freedmen vote in 1979. And if you go up there and you hand them your voting card, they're going to keep it. And that's exactly what they were doing. You know, so John Mcintosh, if I remember right, was the first one who tried to file something, but unfortunately he passed away before it really got off. And then following that, Ron Graham filed with the Descendants organization, and Marilyn can tell you more about that. And so there's been several of those type of cases, and really nothing profound started to happen until the Descendants organization was actually created. And it was created for the 5 tribes, the freedmen of the 5 tribes. And not just the Cherokee freedmen, but there were the case with Ron Graham and Fred Johnson and back, you know, and they actually won their case, by the way, in the court. And then it was actually overturned in the Supreme Court without even a hearing. They just overturned it. No hearing or anything, you know. And so, and then you have the Martin Creek Freedman cases that's been going on since the Vann case was actually resolved in Washington, D.C. So.
Oh, go ahead.
But I will say this. You have the Freedman Descendants, and I've been involved since 2000. And one of the reasons I got involved was I just realized something. It's like, you know, a person fighting Amazon, you know, an employee fighting Amazon. And Amazon has all the money in the world to oppress you with attorneys to keep you from whatever. and you have nothing but what you make every month or every week from your job. And you're supposed to fight this big tribe. And not only that, with the Freedmen, they have a fight against the federal government because the treaty is a two-party treaty. So the Freedmen, because the tribes won't let you sue them, the Freedmen then have to turn around and sue the federal government to say, you're supposed to protect my rights in this treaty. And so they have to go through that legal process. And then when they start that process, the courts say, well, you have to go through the tribal courts. And then you get into a situation as a Freedman descendant, you're not a member of the tribe. And you're fighting for something in a court that won't even recognize you as a citizen to even be in the court. So you got to go back to the federal court and build your way back through that, you know? So, I mean, so what I saw early in 2000 was a bunch of poor people trying to fight a $1 billion industry in Eastern Oklahoma. And it wasn't right, you know? So when some of these people, when they would donate or pay their dues to the Descendants organization of $20 or whatever it is, that was a significant amount of money coming out of their pockets, particularly if the only thing you had was a Social Security check.
Mhm.
So the unfairness of that, the Freedmen, who at one point in history as statehood was some of the wealthiest people in the country because they were landowners. And then the state turns around and passes laws to take this property from them. And even goes into things like, here's the 100-year anniversary of the Tulsa Race Massacre coming up. And we're talking about Greenwood, we're talking about the Freedmen. Those are the people in 1921. And so when you think about these people were landowners and they were dispossessed of these lands, and then in the 1970s, they were dispossessed of their tribal status. And oftentimes they have nothing. And then you have this propaganda machine going on that you could be a member if you could prove you have Indian blood. But no one never told them you never needed Indian blood. Just like they never told a Black person in Georgia, you need white blood to be a citizen of the state of Georgia. But in Indian Territory, they were telling the Black people, you need to go find Granny the Indian. She's the Indian princess. You got to go find her. And so they would spend all their little dollars on researching, and they would come up again and again, the Freedmen rolls. And then the propaganda had worked against them, thinking that the Freedmen rolls were not rolls of the Creek Nation.
Mm-hmm.
They were a garbage roll. And it was all based on a lie that some kind of way is still continued today with many of our tribal members.
Mm-hmm.
You know, and it's sad. And so anyway, Marilyn can tell you more about the Ron Graham's case. So.
Yeah, I mean, from my perspective as someone who has a very limited understanding of this, I mean, I study things like poems and novels, but it seems to me, as I've tried to follow what's happened since 1979 and read whatever I can and talk to people, that the tribe keeps going back to this basis of instead of looking at the overall proposition, just can you prove somebody on the by blood roll? And if you can find it, you can get in, and if you can't, forget it. And so instead of there's a legal term for this when you look at the whole group of people instead of just individuals, they keep going to this individual, basis for trying to resolve these claims. Marilyn, did you want to throw in on this?
Yes. Now is John still having problems speaking?
His picture has disappeared, and that is not a good sign. So
Okay, well, I know I had trouble coming on, and I was in a panic, and so then I said, well, let me try my phone. So maybe it was my computer, I don't know, but anyway, the talking about the cases, Eli already mentioned about Ron Graham and Fred Johnson trying to have going to court. This being overturned in the Creek Supreme Court after the Cherokee Nation v. Nash and Vann case. In the federal court in DC, there were some Creek Freedmen descendants. I know Jeff Kennedy, Rhonda Grayson, Sharon Lindsay Scott. I know those are some of the named plaintiffs. Went up to federal court. Again, the judge told them to come back to the tribal court. I know, and which they are trying to do. And so we don't know when there's going to be a decision on that case. Now, so far as the Cherokee Nation went, there have been people in the Cherokee Nation who said they don't support the Freedmen because the Freedmen didn't try very hard to get their citizenship or make efforts or to keep their citizenship. Well, I disagree with that because, the Freedmen tried to talk to chiefs, tried to talk to the council. I know myself tried to talk to the council. It got shot down. We had Mrs. Bernice Riggs who went to the tribal court. I think that was about 1997. In the tribal court, they said, well, her ancestor that was put down as a freedman did have some Indian blood. That was the ruling of the court. But they said, we're sovereign and we don't have to register, the litigant here. So I wonder if someone like that would be able to say, well, the court says I'm an Indian, so am I an Indian for McGirt? I don't know. But so we had, there was that case, the Lucy Allen case in tribal court, which was filed just a little bit after the Vann case, Vann v. Norton case in 2003. When this petition that was circulated in 2007 was it was 2006 actually, to remove the Freedmen from the tribe. That was challenged in tribal court. Meanwhile, the federal case, continued. So then in 2009, the tribe jumps in and says, well, we're going to file our own case. And they pick out some Freedmen litigants. Later on, this case was virtually combined with the Vann case. And so the tribal council agreed, as well as the chief at that time, Mr. Smith, that a federal judge would make a decision that the tribe would be bound by. So this is how we got to, so after many years, as Eli mentioned, a lot of money. The tribal governments get money from the federal government to run a government, to hire lawyers, to run a tribal court system. Freedmen, again, are individuals. We don't have casinos. We don't get government grants to protect the treaty. And so this was just it's very difficult to go to court to fight for your treaty rights. And even finding attorneys skilled attorneys who do Indian law. Most of them do not want to take Freedmen cases because they know Freedmen people cannot pay them the kinds of monies that tribes can pay them. Although people, when if they take Freedmen cases, then there are tribes who say, well, we don't want to have lawyers who deal with suing tribes or support Freedmen. And as a matter of fact, Mr. John Bealey, who was the lead attorney on the Vann and the Nash cases, he had done significant work for one of the 5 tribes, and they didn't pay him. It was, well, you take it on Freedmen clients. This was in the Seminole case, and we could pay you, but we're not going to do it. So this is some of the problems. It's being, I guess, instead of saying blackball, I guess the word is now canceled. People don't want to be canceled and shut out of a lot of tribal work. And of course, so that's the situation with the Seminole Freedmen. There were actually 2 cases that were going around about the year 2000. The first one was the Davis case, which dealt with the Seminole Freedmen wanting to share in a judgment fund or services provided by a judgment fund. So rather than let the freedmen share in the services, the tribe just said, well, we're just going to put the people out. Then the tribe, some of the services were, some of the tribal services were shut down by the federal government. Again, this was after some Congress began an investigation and the Department of Interior, got involved. So then the tribe sued the Seminole Nation, the Seminole Nation sued the Department of Interior. So this is how we came up with the Seminole the Seminole Nation versus Norton case, where basically the federal judge in Washington, D.C. said that the freedmen have their treaty rights to citizenship, and the Department of Interior is within its rights to protect the treaty and protect the freedmen. Again, the tribe, they reissued the freedmen's cards, and put the people in, so the people continue as second-class citizens. This doesn't mean that they are not making plans to fight against this, but again, all of this is an uphill battle when you're just little people, and similar to taking on Amazon or Intel or the like. And I think a lot of it is the playbook is, well, we have money, big money, and these little people really don't. So if we keep going on long enough, they'll just get tired and walk off, or their lawyers will get tired and walk off or something, and we'll win by default. I think that is the mentality of some of the leaders who oppose the freedmen.
You were talking about finding attorneys a moment ago, and we just found one. He reappeared back on our screen again. So I was going to ask John if you wanted to say something. What we've been talking about while you're off was cases that have come forward since 1979, and I was wondering if you wanted to say anything about cases you've been involved in, or even just the precepts or the principles that are behind some of this.
Well, one on the Delaware case, and the Delaware tribe of Indians came into the Cherokee Nation under the same treaty, or separate section of the treaty, but same treaty as the Freedmen came in. And I did a ton of historical research on the Delawares, and there was some question, well, how can the Delawares become members of the tribe? They're not Cherokee. But it was okay to bring the Delawares in, and also the Shawnee tribe too. And so, but there were some naysayers and some people that, especially in the 70s and later, that they're not Cherokee, but they're full members of the tribe. But it was okay because they're Indian and not Negro. And I've always made the point that there's not much difference between the Delawares and the Shawnees were just as foreign to the Cherokee Nation as the Africans were. So anyway, but I got that didn't go over very well 20 years ago, but it makes sense today.
Yeah. So your point about this double standard is well taken. Maybe moving forward a little bit, let's talk more about McGirt and the fact that McGirt is based so much on this 1866 treaty. And as we've heard in this discussion, people are raising this issue. Can you really just cherry pick from this treaty? We like this part, don't like that part as much. And given the fact that a lot of people see this 1866 treaty as being kind of a gold standard, that it makes a pretty solid statement about jurisdiction and sovereignty. And here in Article 2, we have this inclusion of people of African descent. So, what might be the implications of this recent Supreme Court decision? I'm asking anybody who wants to answer.
Is John still there?
Yeah, he is.
John's a lawyer. Let's hear him speak first.
Yeah.
I'm here. Well, there's the obvious distinctions. One aspect that we're excited about a little bit is the textualism and getting away from just situations and circumstances, and getting back to the text of the treaty and the text of the federal laws. And so that's going to put Indian law on a new foundation, and re-examination of a lot of questions, because the courts have take the Oliphant decision about, do tribes have jurisdiction over non-Indians, and it was based on just a gut feeling that it just ought to be that way. See, but there's no text, in treaties or constitution or anywhere that say tribes should or shouldn't have jurisdiction over anybody that comes onto their land. So anyway, that's the interesting thing that the next stage is re-examining some of the other issues about using this textual approach and sticking to the text of the Constitution, the treaties, and laws.
Yeah.
Because way too many Indian law cases have really muddied the waters by just looking at circumstances.
Can I say something? Historically in the Creek Nation, the freedmen, people of African descent, was under the laws of the Creek Nation. Even the judge who put people to death, Jesse Franklin, was an African who was serving on the Creek Nation Supreme Court. And so the Creeks, when they made their Black people, matter of fact, before their Black people became citizens of the Creek Nation, they were subject to Creek laws. If you look at the old slave codes of the Creek Nation written in 1822, it talks about if your slave kills somebody, this slave is to be put to death. They were subject to tribal laws. And the Black people couldn't marry Indians, and the Black people couldn't own property, and all these things like that made them subject to tribal law even before 1866. And then in 1866, when they became citizens, the treaty just clearly says that they are under the laws and protections of the Creek Nation. It says that right there in Article 2. Not only does it say it, but members of the Light Horse Police were people of African descent. We have many people who were freedmen that were in the Light Horse Police Force and serving as judges, serving as council people. Why wouldn't the laws be, they would be under those laws if they were serving in the House of Kings and the House of Warriors, writing the laws? Why would they write a law that would have no oversight over them? None of this makes any sense. So technically, when we go back to what the US Constitution says, which a treaty is the law of the land, it is it. It supersedes an act of Congress. So when they're talking about this Indian Crimes Act, ACT, Act of Congress, that act, if it's in violation of the treaty, is wrong, period. And will be overturned, just like the McGirt case overturned a bunch of acts in Congress, actually. So it just needs to catch up. But the Creek people need to stop playing this game of they're not tribal members, because when they're doing that, that type of attitude toward people in our jurisdiction is a threat to our sovereignty. It's a threat to our existence, to exclude a whole class of people in your nation based on race. It's just a threat to, and I get it. We want to play Navajo. We want to play those tribes that you see out west, but that's not the reality. 80%, 85% possibly is less than a quarter blood in the Creek Nation. We have what, 500-600 full bloods in the tribe of 90,000 people. I don't know what it is in the Cherokee Nation of nearly 400,000, but in the Creek Nation, that's what it is. So the reality is, to the listeners, when you're talking about the 5 tribes of Indian Territory, 4 in particular, Chickasaw, Choctaw, Creek, and Cherokee, you're mainly talking about white people in Eastern Oklahoma. Let's just be honest. And the majority of those people that are getting enrolled, birth certificates doesn't say Creek Indian on it. It says Caucasian or white or black, but not Indian. But when they become members of the tribe, they're technically becoming an Indian. Because isn't that what the Mankari case is all about? A Indian is a person who is a citizen of a tribe, of a federally recognized tribe, some kind of language like that.
That's correct.
So, you know, reality is at the end of the day, Craig, most of the stuff that's going on against the Freedmen is just anti-Black stuff in Eastern Oklahoma, typically by white Indians. Let's just be honest. And so, and that goes back to a bunch of Jim Crow upbringing from decade after decade after decade since statehood. And we're actually the product of that, you know, mental thinking of what Jim Crow has done to us. Basically continue to separate us by race instead of nationality. When you look at the old testimonies of the conditions of Indians and Indian territories, I encourage your viewers to go read these things online. The conditions of Indians and Indian territory, where the US Senate came to Indian territory to interview freedmen and Indians by blood people, they would always begin their question with one statement: what is your nationality? They never asked people what their race was. They would always say, what is your nationality? And the freedman would say, I'm Creek. The Indian would say, I'm Creek. That's my nationality. You know, so we've left that and we got into a club mentality of people in and people out. And unfortunately, it's going to blow up on us if we don't fix it. I still think the freedmen being disenfranchised and kept at bay from their rights is the greatest threat to Creek Nation sovereignty there is. That exists.
Following up on these ideas, I want to think about this whole issue for a moment outside of these technicalities, to whatever degree this is possible, and to think about these moral questions that you're bringing up and these ethical questions. And I often ask this question of students when I'm teaching about all of this, about, you know, the technical stuff can be hard for people to understand, especially if they're not from Oklahoma and haven't really delved into all of this history and context. But, you know, on the ethical front, there are all these issues. And I was kind of reminded of something you said earlier that I've thought about a lot. It's like, if I come to your house for a party, don't tell me after I've been to the party for 113 years that I have to leave the party, because after 113 years, I'm already part of the party. I'm integrated into it. I'm related to you. We've got relatives. I mean, it's too late. I mean, you know, that's the legacy that you have to deal with, having had the institution of slavery, among other things. So just turning to this as kind of a moral or ethical issue, what's at stake here?
I think the sovereignty of the Creek Nation is at stake. And not only that, you know, right now we're dealing with the Seminole issue, where the Seminole Freedmen won their legal case in 1998, Freedman, and Bill Clinton was president at the time. And the Department of Interior fought for the Freedmen along with their attorney, John Veely. And this is before the Descendants organization. And the Seminole Freedmen rights were established, but they've been attacked from day one. And just recently, when the tribe got their CARES Act fund, the tribe told the Freedmen, well, you're not getting part of the money. You're not getting, even though their treaty says they're entitled to the money. The tribe decided, well, the Negroes are not going to get the money. Then when the vaccines came out in December and started shipping to the tribes, guess who didn't get the vaccination? The Freedmen. And they were told once the vaccination was opened up to even the non-Indians, non-members, then they can get in line now. Now they're tribal members. And you're talking about that is some type of deadly racism right there. And I'm hoping that the select committee in Washington in Congress, which is the new committee formed to oversee how the CARES Act and the American Recovery Act monies are actually spent, that they drag the Seminole Nation over to there to a hearing and explain why were the black people denied their funds, except for the fact they're just the black members. Guess who also got denied those funds? The Creek Freedmen, who in the treaty are entitled to an equal share of the national funds. They got to explain to Congress, why didn't the Freedmen get their share of the funds? And the Creek Nation say, well, they're not citizens. That's not good enough, because the treaty, which is the law of the land, according to the US Constitution, says they are entitled to equal share of the funds. You know, I think what's happening in Indian Territory is that Black Lives Matter has finally arrived. And people have had enough of it. And there's so much attention being paid to the Tulsa Race Massacre right now. In May would be the 100-year anniversary. There's a big museum opening up. Oprah's been here doing a movie about it. The National Geographic, James LeBron's on, and I mean, just documentary people after documentary people. And what they've done differently this time is that they're including the voice of the Freedman descendants. Oklahoma has two classes of Black people here. I really want you to understand that. You have the state Black people who are from the states that immigrated here after statehood. They have no ties to the 5 tribes at all. Some of them immigrated on the land runs to Oklahoma Territory in 1889 and created a town like Langston, where Langston University is today. But in Indian Territory, the Black people who have been here since the 1820s, even before the removal, we forget about the Mcintosh family and the Perryman family, who left Alabama because William McIntosh illegally signed a treaty that he ended up being assassinated for, and his family and a lot of the slavers of the Creek Nation left the Creek Nation in Alabama in 1827 and came across the Mississippi River and settled just east of Tulsa in the Three Rivers area of the Verdigris, which is right just down the road from me here in Tulsa. They've been here since the 1820s. So you got the Indians Negro, which is what history books say and what the federal documents refer to. And you have the state Blacks who immigrated here after statehood. And for decades, it's been the state Blacks story here in Oklahoma. And the Freedman story has been ignored. And mainly because there's been such a opposition for real history in Oklahoma about who the Freedmen are. Who are the Black Indians of Indian Territory? Who are these Africans of the 5 tribes? Who are these people? Their stories are rarely talked about. They're certainly not in public school books in Oklahoma, nowhere. Nowhere would you find in a public school book in the state of Oklahoma that the Creek Nation enslaved Black people. And if you look at the maps, when they talk about slavery, they only show the Confederate South. They leave out Indian Territory completely. So you never hear about the Civil War battles here. You never hear about the slavers who were the prominent families of Indian Territory here. You never hear this stuff. And so when the Freedmen started to stomp and make loud noise that get your feet off our necks to these tribal chiefs, and organizations like Marilyn appeared, and attorneys that are willing to fight like John Paris and John Veely and others, That's when things started to change. And right now with the 1921 Tulsa Race Massacre at the center of attention, people are realizing, oh my God, Black Wall Street was really 3 million acres of Black land that was owned in eastern Oklahoma. It wasn't a main street. It was the fact that Black people, but you know, Oklahoma statehood, the economy was two things. In 1907, when Oklahoma became a state, it was agriculture, and then it was oil and gas production. The Glen Pool was discovered in 1905 in the Creek Nation. It was the Saudi Arabia of the world right here. And Freedman allotments made up part of that. And so all of a sudden you had these wealthy Black people who were members of an Indian tribe. They were not state Black people. They were Black people of Indian territory with tribal status. And their history has totally disappeared. And when the tribes are asked about it, when you go down to the different preservation offices and libraries of these tribes, they go, oh, well, we don't talk about those things. Or we don't have your history here. And then when you have writers to want to write about it, and they go to the tribes for information, they're given misinformation. And these people put that junk in their books as if it was true. And then you have to go back and say, you know, for example, Arkansas colored, Norfolk colored, and Canadian colored, 3 tribal towns of the Creek Nation. And a lot of the history books in Oklahoma about all Black towns, they're listed there as all Black towns, like they had a post office and a main street, and they were not towns at all. They were just political bands within the Muscogee Creek Nation for political statuses. But the Creek Nation allowed that junk to be placed in books. So we're not only fighting the tribe for truth, we're fighting the state Black narrative of what is the real truth. And so when we go to courts, we're having to educate judges, educate attorneys, educate members of Congress, educate people like it listening to you on who these people are. And these ain't Black people playing Indian. I still have not met freedmen who run around with feathers and the powwows and stuff. That's not who they are. But they are legal members of the 5 tribes with legal ties. They actually have a legal documented tie to the 5 civilized tribes, not stuff based on hearsay and family folklore. Grandma was a Blackfoot Indian, all of that stuff that you hear. That's not what these people are or who they are. And so anyway, I encourage your viewers to not only listen to the Freedmen, but get involved, because when you see wrong, you got to do something about it. There's nothing right about what's going on here. These tribes literally have their feet on the necks of these people. And it's just not right. I'm a Creek citizen. I descend from both the slaver and the enslaved. And they want to tell me, well, you're in the tribe, why don't you shut up? Well, that's why I'm talking, because I'm in the tribe.
We have a number of audience members clamoring to ask questions. So I was wondering if, before we turn to members of the general public, if Marilyn or John also want to add onto this discussion of just sort of thinking that outside maybe the legal ins and outs, but whatever the ethical implications of these issues are. So Marilyn or John, would you like to weigh in on this?
Let me jump in here first. Okay, moral and ethical issues. I mean, okay, let's just take this from the standpoint of the United States. It's only for treason that a person in this country can lose their citizenship. Is one of the few ways that a person can have their citizenship removed by the government if they are a native born citizen. but that doesn't take away the citizenship of their children. There were people who were deemed traitors in the history of the Creek Nation. That William Mcintosh, for instance, when he signed the Treaty of Indian Springs, the man was murdered, but his children were not cast out as Creek citizens. I mean, Daniel McIntosh, for instance, became a very prominent man. What is a treason that the Creek Freedmen have done, the Freedmen, or any other Freedmen? No treason. The Freedmen, they didn't sign the fraudulent treaties. They did not, they were not marching with Andrew Jackson to drive the people from the old homelands. None of these things. The only thing wrong with the Freedmen is that their ancestors were weak people who could be persecuted, who could be used, and now do not have enough political power to really enforce their treaty rights. I mean, and to say that, well, we have a sovereign right to do what we want. No tribe has a sovereign right to do exactly what they want to. The Major Crimes Act, for instance, no tribe can execute criminals. Nobody, I haven't even seen anyone try to put that in a constitution. So, okay, you say the United States has not abided by the 1866 treaty or others. So why take that out on the freedmen? If the state, if the federal government, if they are not doing something right, then it's time to go out and go to a lawsuit against them. But do not do it against the freedmen who went and fought in the Indian Home Guards in order to protect the nations during the Civil War, who nursed babies, chopped wood, who did all of these things. And some people say, well, the UN, they say that we can indigenous populations can make their own decisions, but minorities have a right not to be displaced, not to be nationalized, and stop it. If the freedmen, as well as others in the tribe, had not been granted U.S. citizenship under this 5-tribe citizenship tract of 1901, we would be stateless people. Is that right? Why? What again have the freedmen done to deserve such treatment? I also want to point out, also emphasize, as Attorney Paris has said, now, the Delaware, the Shawnee were adopted into the Cherokee Nation based on the 1866 treaty. And of course, there were subsequent agreements that went in there. There's never been a movement to remove those people. Then from the tribe, from the Cherokee Nation, or any of the Creek citizens that were adopted during the 1820s by an agreement between the Creek Nation and the Cherokee Nation. Other tribes that had captives, your Comanche, your Kiowas, who adopted whites, they were put on captive rolls. They received allotments. Yet those individuals and those individuals' descendants, they continue on as citizens in these tribes without treaties. So the only thing I'm seeing greed, color. These are the reasons that the freedmen are being denationalized or being discriminated against. So it's time for apartheid to end in the 21st century.
Thank you, Marilyn. Those are powerful points. And John, do you have something to say about the ethical dimension of this, or maybe what motivates you to do this kind of advocacy?
I think it's just interesting to me. I got started on it as when I was full-time employee of the tribe, but it's a fascinating subject and cutting edge law. But it's one of the the continuing violation of civil rights is just, as Eli's pointed out eloquently, that is a terrible ethical stain on the country right now, that we still have civil rights problems of this magnitude in the United States. And so but it needs to be rectified soon.
Okay.
And I really think that a lot of going back from a legal history, criminal law has formed a lot of Indian law because, about who's an Indian, what's Indian territory. A lot of those decisions were made in the context of people committing crimes. And it continues with McGirt and Murphy. So Hogner and Bossy and all those. So that, who is an Indian, because it mattered with liquor laws way back and different things. So jurisdictional challenges. So these are not new issues, but they come up in the context of criminal laws. So we will see how the criminal courts rule on whether freedmen are subject to the state law or tribal law under McGirt. I know I got a call from the Federal Public Defender's Office in Oklahoma City that they're wrestling with the issue because they have a person charged with murder and a freedman charged with murder in Choctaw territory, I think it was, or Chickasaw, and so they're a lot of people are struggling with this around the jurisdictions. I think it's going to be the next step in getting a decision, the next decision that will clarify all of this.
All right, Megan is helping me feed some questions from the audience. So do you have one you want to throw at us, Megan, from our listening viewers?
Sure. Thank you all so much for this really wonderful discussion. So I'll ask one question that's more of a historical question, and then there are a couple about more contemporary issues. So the question, Dr. Womack mentioned that there are documented accounts of escaped slaves living among indigenous peoples in the Americas as early as the 1500s. And this listener wants to know where to read more about this. Can you suggest any sources?
The Hernando de Soto expedition had a writer, and those writings are published in a book. And I can't think of the title of the book right now, but somebody else might. But if you
Just Google
it, yeah, Google Hernando de Soto,
It shows up.
It'll
Black people.
But it's a book that's published and completely available at every library around practically. So yeah.
All right, good answer. Just Google it. I like it. Thank you all so much. So one question is, and this may have been answered by John Paris's response, thinking about the criminal courts. But the question is more about, do you think the Freedmen will get any support with the new administration and Secretary Deb Howland on these issues?
I do. She's happened to be a friend of mine. And I think the more she will learn about this, you're different when you're in Congress because you're constantly raising money. And unfortunately, what's happened in Indian country on disparaging crazy issues like the booting out of the freedmen, for example. Sometimes tribes think this is a threat to their sovereignty if they don't bind together and help this one tribe kick out whoever they want to kick out. That happens in California, it happens here. And so when you're a member of Congress, you're constantly raising money every 2 years. And unfortunately, I'm not saying she did this, but a lot of them have done this. The tribes, when they want something done, they know how to write a check and they know how to give to campaigns. And basically it's a pay-to-play system in Washington often. And on this particular issue with the Freedmen, one of the fiercest adversaries against the Freedmen have been the NCAI, the National Congress of American Indians. And what they've done, they've gotten smart. If they don't want the CBC, the Congressional Black Caucus, to support the Freedmen, they start holding fundraisers. And that's just the truth. And so, but right now, we're in a different time than we were 5 years ago. Black Lives Matter over the last few years, particularly since last summer, has changed a lot. And like the case that's going on the TV right now, with Floyd being murdered by a cop. You know, all of that is in the psyche of the Americans now, white, black, red, whatever, you know, Asian, whatever. Racism, people are just had enough of it. And particularly when you got a class of racist people that have been awakened in the last 4 years to try to push their hatred under that last administration. And then there's an opposition now to push back against it and push back not only against Black racism, but all racism, including the racism against the freedmen of the 5 tribes. And so, unfortunately, under the Obama administration, a lot of this got ignored. But I think under the Biden administration, things are different, you know, and members of Congress, not just in the Congressional Black Caucus, but just other members of Congress are like, you know, one of the best supporters of the freedmen was actually Barney Frank. Congressman Barney Frank from Massachusetts was a champion for the freedmen. He had nothing to do with Oklahoma or what was going on in Oklahoma, but he was chair of financial services, which oversaw HUD, the subcommittee on HUD, and that committee dealt with Indian housing. And to help the freedmen out, guess what he did? He read the treaty. And he saw that the Cherokee freedmen had rights and the Cherokee Nation couldn't kick these people out. And that the treaty said that they were entitled to the funds that were given to the tribe. And so, you know, so what actually passed in the Nehasa bill was, if you ever want to read the Nehasa bill written in 2008, signed by George Bush Jr., the last paragraph basically says if the Cherokees kicked the Blacks out without a federal court order, they were going to lose their housing money. And they did, and they lost their housing money. And it wasn't until, you know, they actually stopped their crap and then elected a new chief, Bill John Baker, did they get that money back. And the Cherokee freedmen, particularly since they won their federal case, have been receiving Indian housing services, you know? So Deb, I think she's new, you know, I was kind of disappointed that the first tribe she actually called was the Creek Nation. And I hope that wasn't a signal to tell the freedmen to go away. I'm looking at it as a signal that she's actually going to pay attention to what the Creeks are actually doing, not just to the freedmen, but to all of their tribal members. Let's just look at the Creek Nation, for example. It's just not about the freedmen. The racism is not just about the freedmen and the Creek Nation. In our Creek Constitution, and this is very important to you guys who are you know, reading and learning about McGirt. In our Constitution, you have to be a quarter blood to run for political office. You look at the population of the Creek Nation, you got 85% of Creek people, less than a quarter blood, that cannot run for office. These are current tribal members that cannot hold elected office. Then you have the council and the chief, the way it's set up, you have to live in a certain district within the Creek Nation to run for office. We have 2 council persons per district. We have basically 8 districts, you know, and 16 council members. And 2 of them have to live in a particular district, like in Tulsa district, for example, which is Tulsa County. You have to live in Tulsa district, and you have to be over a quarter blood, and you could have never committed a felony in your life, not when you're 18 years old and you made a mistake smoking pot, ever. So the number, the pool to elect people is so low out of the 90,000 population. You have to be age, you have to be over a certain blood quantum, you have to live in a certain area, you have to be able to afford to run a campaign. So our basis for electing tribal leaders on our council and in our executive office is so small. And these are the very people who pick the judges. Are you following me? So even when you're looking at McGirt and you're looking at who gets to pick the judges, and oftentimes, you know, if you want a job, you're going to do what the elective office says, or they have the power to shut the court down. It's very layered. You know, so the racism isn't just against the Freedmen. It's against 85% of the people that are currently enrolled in the tribe. So I'm hoping Deb Secretary Deb Haaland will do the right thing. And I hope the person she picks for Assistant Secretary of the BIA will do the right thing. If they don't, I can guarantee you Eli Grayson is gonna hold a sign up saying, Deb Haaland, you're a racist. And you need to do the right thing and support the treaty. And I believe she's gonna do the right thing as a friend, and as a good person. So I hope that answers the question. I know it's a lot, but hey, you know, Dr. Womack knows me. And I
Yeah,
hope there are adults on here.
You definitely answered that question. Thank you so much. So we're already at 6 o'clock and we've already taken up so much of your time. It's been amazing, but if we could just have one more question. So Eli Grayson mentioned that people should get involved. And so I just want to throw out the question of how can people get involved? I think you've given passionate arguments about why this matters. Can you give any suggestions of how people in our community could get involved?
Okay, I'll jump in here. Well, of course, if a person is part of the tribal community, for instance, say a Creek citizen, Cherokee citizen, or the like, they should try to be more involved, register to vote, go to Oklahoma, go to the holiday. Not to say that the holiday is not, and some of these things, you know, are not open to other people, but there's a lot of people who are members of tribes that don't participate. For instance, in your Cherokee Nation and the Creek Nation, the number of people who say are registered voters or participate in elections is very little. Now, there are things that a person can do with, regardless of whether they have any kind of heritage. If they are concerned about the Freedmen as a human rights issue, then certainly when we ask for people to call their Congress people or call their senators over something, you know, if you're on Facebook, the Descendants of Freedmen, we have a Facebook page. We have a website. Also, there's a 501c3 African Indians Foundation we're president of. We have a website and a Facebook page. You know, sometimes we need volunteers. Sometimes we need folks to, you know, make some donations. We encourage people to read books, read articles, find out here about the Freedmen and the treaties. I mean, you know, some tribal leaders have put things out there about the Freedmen that are just some black people who snuck in from Arkansas or the like. But again, you have the slave schedules of 1860, which make it clear that there were people who were citizens of tribes, that they had 50 slaves or 100 slaves, not by name, but by age, whether they were a man or a woman. It's important to know about history, and yes, it's a little more complicated in the sense that because we're talking about treaties, but every black person does not have a treaty right to citizenship. Although some people that oppose the Freedmen, they have said things like, well, if the freedmen come in, any black person walking up and down the street can come in. No. In the Cherokee Nation, there were like 41,000 people who were listed on the Dawes Rolls. That included adopted whites, adopted Creeks, adopted Delaware, adopted Shawnee, freedmen, full blood, half blood, whatever. That is the descendants of those people are the citizens of the tribe today. I think in the Creek Nation, there were about 18,000 people that were put on all sections of the Dawes Rolls. About a third of them were freedmen. I think it's less than 10 white people that were that were in there. But this is the thing. There are ways to get involved. The Descendants website is www.freedmenfivetribes.com. Our Facebook page is Descendants of Freedmen of the Five Tribes. I know myself, I have a personal page. I put up a lot of things up on that too. Marilyn Vann, I'm on Facebook. I'm wearing a powwow shawl. There's so I'm easy to find. But that's the thing. Get involved, get educated. And then, as I said, if we have a call to action, sometimes when we've had demonstrations, we've had folks come from the East Coast or the West Coast to stand up there and march in front of the BIA building. But yes, a lot of times there's folks that say, well, gosh, things need to change, but a lot of times you just don't have enough warriors.
Yeah, I just wanted to say that, as many of you all know, this is a conversation that can get very lively. And I just appreciate the fact that ours has been lively in a way that's been both productive and highly informative, and that's no small task. So I want to thank everybody who's joined us today. I don't know if there's any parting comments that any of you all would like to convey on the panel, but Mado, just thanks, and we appreciate all your years of really going to the barricades over this issue, because as I was saying before, to me, it's at the very heart of what it means to be sovereign, what it means about citizenship, what it means to be a tribal person. So my hat's off to you, and I'm deeply appreciative.
I just want to make let me just make one or two parting comments. We don't know what's going to come down with McGirt and effects of the freedmen. I definitely believe that McGirt, because it weighed so much, depended on the treaty rights of the Creek Nation. You can't have Article 3 and then shut your eyes on Article 2. Whether or not how the courts are going to make decisions on final decisions on whether or not freedmen's or Indians or not. Again, it's only been in more recent years that that degrees of blood even came into play at all, or CDIB cards. So whether or not there's going to be ways that first I would say that if a freedman is not registered in a tribe, I think that a court is not going to say that you qualify for overturning of your sentence. If you are a member of a tribe, the definition of an Indian, it varies and it varies and it varies. But it's going to be interesting to see whether or not we're going to have different classes of tribal members again. So, but anyway, it's great to see everybody, and we appreciate being on here.
Appreciate you, Doctor, for holding this and allowing the freedmen to have a voice. This has gone on too long. I mean, it's just ridiculous that we deal with this in 2021. I often think about, we use an antiquated word called freedmen. Mississippi, Georgia, Alabama, Tennessee used to have freedmen bureaus. And the Black people down there after the Civil War were called freedmen. Georgia's freedmen, Alabama's freedmen. We had the Creek Freedmen, we had the Cherokee Freedmen. These were all people formerly enslaved by the tribes or the states. But guess what? Nobody in Georgia, Black, going around calling themselves a Georgia Freedman, because nobody has been branded with those badges of slavery anymore. And yet in Indian Territory, the Freedmen descendants are having to wear a badge of slavery, reminding them that their ancestors were enslaved by these tribes. Just ridiculous that we do this today in 2021. It's crazy. So I encourage the tribes, the Creek Nation chief, Creek Nation council, to do the right thing. You don't need the federal government to tell you to do the right thing. Do some sovereignty. If you
Exactly, yeah.
sovereignty, shake up the sovereignty bowl and do the right thing. Just declare it and do the right thing instead of waiting on a federal to make this decision for you.
Yeah, I think that's such an interesting point of just this possibility of turning the whole thing around, and instead of seeing this issue or seeing the freedmen as some kind of liability, to see them as this amazing opportunity to actually act like a sovereign nation and make some decisions. Yeah.
You know, when Black people in Indian Territory hear the tribes say sovereignty, it's usually something against them. And it reminds me of George Wallace in Alabama. We have a state right to treat the Negroes the way we want to treat them. Here in Indian Territory, we say we have the sovereign right to treat the Negroes the way we want to treat them. It's the same thing. And so sovereignty to the freedmen, that word is now a bad word instead of a good word. And it's the tribe's fault. They've made it a dirty word to the freedmen. And it's awful, because it should be something that all the people who have a right to be a member of these tribes celebrate and wear it with pride. Instead, it's been used as a badge. Thank you.
on that note,
Wine or beer. Hello.
Hadam Giachaflis, we'll see you sometime, hopefully not in the too distant future. And thank you all for sticking with us in the audience for this whole time. Thank you to the panelists. Thank you for Megan and Elizabeth and the Carlos Museum that keeps supporting events like this for us. So much appreciated.
We love doing it, Craig. Thank you. Bye-bye.
Good night.
What oh?
Yes.